So here's the deal. Both sides have just filed their briefs on the preliminary hearing in the Tyler Robinson case, and it really appears that they're not even talking about the same case in some way. So I'm just going to give you a thing. The state wrote a brief about why and how they believe Tyler Robinson shot Charlie Kirk. The defense wrote a brief about something else entirely, and what they're actually fighting over decides whether this is a death penalty case or not. So a couple of things. Hey, my name is Travis Christiansen. I've been doing criminal defense for over 20 years here in southern Utah. I don't represent anybody. I don't have a dog in the fight, but I've been doing criminal defense law for a long time. I have done a murder jury trial, and so I've got some insights I think might be helpful as we look at this situation. So I am looking at some notes because there was a lot here. There were 60 pages in these briefs. So I'm going to refer to my notes. I apologize for that, but it's going to help me get some of these kind of things straight. So a quick foundation. This is a preliminary hearing. It is not a trial. The burden of proof for a preliminary hearing is probable cause, and it's a low bar. And here's what that means. The Utah Supreme Court has actually called it a low bar. This is not beyond a reasonable doubt that they would have to show at a trial. It's very low. And the other thing is they have to view the evidence in the light most favorable to the prosecutor. So if there's two theories, one, the guy's guilty, one, he's innocent, at preliminary hearing, they have to do the guilty one. So they don't have to even rule out. It's just the two explanations both fit. Judge takes the state's version of events, and that's essentially all that happens. So when I walk into a preliminary hearing, most of the time my client is going to get bound over because usually they've got enough evidence to muster probable cause. It's not even preponderance in a civil case. It's lower even than that. And so it's a really low standard that we look at in these kind of things. And we figure out, where it is and what's going on. So because the defense in this case filed a brief and didn't even really fight the murder charge at all, and I'll stick around, I'll show you what they fought instead. This is what I think is the smartest move they could have done. So what did the state file? The state filed what we would expect them to file. It says, look, this is as likely of a straightforward bind-over decision as a court will ever see. And so they lay out the evidence in their layers. First off, they talk about the admissions, some of the things that they allege that Mr. Robinson put in text messages and instant messages to various people and when he turned himself in. They talk about the physical evidence. They found the Mauser bolt action 30-06 wrapped in a towel. His DNA is on the trigger, on the receiver, the fired casing, the towel, and the screwdriver left on the roof. They've got the videos. Hundreds of hours of video camera surveillance tracking the figure on the Losi Center roof into a prone position on the edge, up and running at a certain time and off the back of the building. There's a lot of evidence for a probable cause hearing, probably more than they needed to, but they're seeking the death penalty, so they're going to try and get as much in there as they can. So this is what happens when the state gets to one specific element, and that's where the brief they've got to do a lot. They've got to work a lot harder. So one sentence, this whole thing turns on. So in Utah, murder isn't automatically a death penalty situation. You've got to meet the aggravating factors. To make someone eligible for the death penalty, you've got to have an aggravating circumstance. So in this one, the defendant, they allege, and this is what they said, knowingly created a great risk of death to another individual other than the deceased individual and the actor. So that's it. One aggravator, one sentence, is that he knowingly put other people at risk. So if that survives, this is a capital case, and Tyler Robinson can be sentenced to death if he is convicted in the end. If that part doesn't survive, it isn't a death penalty case. Now, I'm going to give some of my opinion. I think that Utah politicians came out too quickly and said they were going to seek the death penalty in this case before enough evidence had really been gathered to determine what was going to happen. So I think that was a political mistake that has boxed this prosecutor in, maybe that they want to be boxed in. So a couple of things on that. And it gets technical in a way that actually matters because the defense makes one argument about basic geometry that's the strongest thing in their brief. So let's go to that. The state's other theory one about why this is, puts other people at risk. And that is theory one in the line of fire. There was a man standing in front of Charlie Kirk asking him a question when the shot was fired. Several more people stood behind him. And the state says all of them were in the shooter's line of fire. So all of them in what the law calls the zone of danger. That's their theory. Theory number two is really anybody nearby. Ricochet, that kind of situation. But they were close enough that ricocheting, a stray, a really bad miss, that they could have been hit. They add two supporting inferences. He did load 4 rounds, which the state says they expected he might miss. And his own practice target showed shots that missed the bullseye entirely, missed the paper. So apparently they've done some research and found where he has practiced shooting this and other guns, and he had some misses in what was going on. Now, here's the defense's response. Number one, it's the geometry issue. So does the geometry make sense? So the defense makes a point that's almost embarrassingly simple. The shooter was 68 feet above the courtyard and 410 feet away. Charlie Kirk was seated on an elevated platform. The medical examiner found the bullet's path went front to back downward. So the round came in on a descending angle over the crowd into an elevated target, which means the man asking the question, who was down below in front, separated by a barrier, a strip of grass, and a table, was not in the line of fire in any physical sense. And the defense makes the argument in one line. If he had been in the line of fire, he would have been hit. So he wasn't in the line of fire. So that other people at risk and the capital aggravator, that one guy standing there, isn't enough. The state's brief never answers, and they do get a chance to reply to that, and I assume they will. It argues horizontal alignment and really doesn't address that vertical angle. So that's the hold. Now, I assume the state's going to address that because they get to rebut, because they're the moving party. They get the last say, and that'll probably come out in a week or so. The defense caught a couple of other things. The state wrote that at least 2 people were standing under the tent. The defense says the state's own video exhibits contradict that. The state described the questioner as a few feet from Kirk. The defense points out no witness ever measured the distance. Sloppy police work. They didn't measure that distance. They did figure out exactly how far away this person was. They probably could have done that with some video forensics and some experts. But again, this is preliminary hearing. They may not have needed to do that at this point to get there. Now, let's talk about the law. The defense's second argument is about how narrow this aggravator has to be. Under the 8th Amendment, an aggravating factor has to actually narrow the group of people eligible for death. If it applies to every murder, it's unconstitutional. So courts read these things narrowly on purpose. The defense walks through all 3 times Utah Supreme Court has addressed this, which is the Pierre case in 1977, the Johnson case in 1987, and Sosa Hurtado in 2019, and points out in every one of them, the defendant fired multiple rounds, aimed some of that conduct at a third person, and actually hit or nearly hit somebody other than the murder victim. So in this case, we've got 1 shot, 1 victim, Charlie Kirk. So with the scoped rifle, a 30-06, 410 feet, not even 150 yards, with a 30-06, I shoot guns myself. That is a shot that anyone with decent marksmanship should be able to make. And he hit exactly what he was aiming at, exactly what the text messages alleged he was aiming at. So that's issue. And then, so they make a good argument that this aggravator shouldn't apply because there weren't substantial risk to other people. And if the judge finds that, then the death penalty is off the table. And quite frankly, in this case, that might be the biggest victory for the defense that they could have. So then there's other 3 battles in this, those don't really matter. We're looking at this. So a couple of things. Count 6 in the information. He told his roommate to cover up for him and to stay silent. That could be seen as obstruction of justice. And witness tampering, when you're looking at capital murder, this offense doesn't really matter too much. The count 7, committing a violent offense in the presence of a child under 14, requires that he knew there was a child present that was under 14. That's pretty thin on the part of the state, but they'll probably get it bound over at prelim, but they may not be able to prove that particular offense at trial. And the victim targeting enhancement. The state has to show he selected Kirk because of his political expression. There is some evidence, a text saying, "I've had enough of his hatred," a pastor's written statement describing Kirk's beliefs, and the engraved rifle cartridges, one which reads, "A fascist catch." Here's what I noticed. The defense's brief attacks the text and attacks the pastor's statement in detail. It never addresses the engravings. That's the single most direct piece of evidence on political motive in the entire record, and the defense ignored it or missed it entirely, or maybe they just realized we're sunk on that one. Doesn't make a lot of sense to argue something that we know is probably a loser. So, my predictions, here's what happened. My honest read, judge is going to bind over on everything because, again, this is preliminary hearing, including, I think, he's going to bind over the argument. Not because the defense is weak, arguments are weak, but if there's two arguments that make sense, the judge has got to, at this point, rule in favor of the state on probable cause on those issues. But they have to check it. Now, here's the thing that you've got to look at. It does clear that low bar. High-powered rifle, several thousand people in an open amphitheater. But it wouldn't, even if it wouldn't survive in a jury instruction later. So at trial, the aggravator might be dead. Now, which it's, at this point, the defense is probably okay with that. But they've got that argument out there. They've made hay with it. They've pointed it out. It's a great argument. And I've even had situations when I've done cases where at bind over, the judge will turn to the state and say, "Look, I'm binding it over, but this is a really weak part of your case. I suggest you negotiate this." Now, will he say that publicly in this case? Probably not. But he might tell the prosecutors that in a chambers conference where it's a more confidential setting between attorneys. So that is a possibility. The judge does that commentary because, they may not win on that, and then they've spent a lot of resources on a death penalty case that might not be there. So there's one more thing buried in these arguments, and it's that nobody really has picked up on, is that the court would not let the defense subpoena the roommate from out of state to testify. Nearly everything about this case goes through that. That was interesting. They did have that interview with a cop that they played, and that's okay at preliminary hearing under the rules 1102 and the rules of evidence. They can do that. You don't have to have people present for prelim. But when it comes time for trial, that roommate's going to have to be there identifying. So here's the thing. Two documents, two completely different theories of the case, which is what I would expect. If I were doing this, my brief would be very different from what the state briefed, because that's my job as a defense attorney, to point out the weaknesses of the state, make those arguments now. And as I stated in a prior video about this, if they don't make some of these arguments now, the judge may say, "You can't bring a motion to quash. We already had that hearing. We already argued it, and you were told to brief it, and you didn't." The other thing that was interesting is these briefs were beyond the normal limits of length. So clearly the judges wanted them to make every possible argument they could. So I still think he's not going to entertain much in the way of motions to quash. But there's nothing in this video as legal advice. I'm not involved in this case. Mr. Robinson is presumed innocent of every one of these charges, and these are allegations and arguments, not findings. I'm just giving my hot take on it as a defense attorney here in Utah that's been doing this for over 20 years, and a couple of things that I'm looking at as we look at this thing. So listen, if you want to know more, I'd love to chat about it. Reach out to us. Again, my name is Travis Christiansen with Greater Zion Law.